before you can assimilate here sa pamumuhay po dito sa Amerika, kailangan makapunta muna kayo dito at kailangan nasa ayos po ang inyong mga dokumento tungkol sa immigration.
This American Dream segment is brought to you by Aquino & Lowe Law Firm, answering your immigration questions.
Attorney Richard Lowe joining us from Aquino & Lowe Law Firm. Hello, Happy New Year to you.
Hello, Happy New Year to you.
And we have two very interesting scenarios here to discuss, but also basically very similar. A lot of Filipinos go through this, the subject of illegitimate children. For those of you with secrets, you may mga sekretong junior po sa Pilipinas and you want to bring them over. Is that even possible? Let's take a look at Reynaldo's case. He is being petitioned by his LPR father, so permanent green card holder or permanent resident. While waiting for the petition to become current, he fathers a child with his longtime girlfriend. What effect does the birth of the child have on his petition through his father? What will happen to the child if Reynaldo comes to the U.S.? So basically, Richard, can Reynaldo or should Reynaldo even divulge that he's not married?
Right, he's not married. And I think this problem comes up because people don't want to get married because they're in that F2B category and they can't get married or else they lose the petition. And so they think, well, if I have a child, then I'm also going to run into problems. But this isn't the case, and this is actually very sad because sometimes the child can come with the parent as they come in.
Right.
They don't have to wait. If you just do this correctly, admit it to the embassy. It causes more problems not to reveal than it does to reveal at this point.
Right. So it's better to just deal with it then rather than, you know, go through with it, conceal, and then deal with the repercussions later.
Absolutely. Absolutely.
Okay. All right. Here's another case, and we can discuss both together. Mario has been married for 20 years and has 2 children through the marriage. He and his family came to the U.S. 15 years ago, so he's here with his legitimate family. However, while married before coming to the U.S., Mario fathered a child with his ex-girlfriend. His wife and family do not know about the child, and Mario has had very little contact with the child. But now Mario wants to bring the child to the U.S. Can he?
Yeah, this is, again, the similar kind of issue, except now he's here. Now, what's really going on is taking a child that's born out of wedlock and legitimating him. We call that legitimation. So making that child the same rights as the child that was born in wedlock. And you can do this through a legal process called legitimation. Okay. And that involves lots of legal steps. You know, you have to take an action in either the child's residence or the father's residence. The child has to be under 18 when you do it, and you have to have legal custody. And it has to be the natural father.
So is there parental tests or DNA or anything that's involved in this?
Yes, this is actually an issue that comes up, is that more and more the embassies are requiring DNA to show that you are actually the father. And notice that this only comes up in the situation of the father. The mother is presumed to be the mother because they're on the birth certificate, don't have this issue about legitimation as far as immigration is concerned.
Okay.
So this is really a father issue. And the problem with Filipinos is that you cannot legitimate in the Philippines unless you marry.
Right.
And in the second situation, where he was already married when he fathered your child, you can't legitimate if you could not have married at the time that you fathered the child.
Oh, okay.
So in the Philippines, the second situation, they could never legitimate that child under Philippine law.
So what can we do now?
Well, you can legitimate under California law or under the law of the country that you moved to or the state that you moved to after that, if all of those legitimating acts happen under the age of 18. So it gets complicated. Now, the other fallback...
So, hold on. Are you saying that if, let's say, you have a child out of wedlock, as long as he or she is before he or she reaches before the 18th birthday, you can still apply for legitimization, or
you can do legitimating acts prior to age 18 that will give the child legitimate status under immigration law in the United States. Not necessarily under the law of the Philippines, but under immigration law, so that child can come in, you can petition that child, and the child can be derivative beneficiary of you and come in with you as a derivative beneficiary.
What if you conceal it too long that the child is now over 18?
Yeah, that's really the problem, is that this gets concealed. And you can see in our second scenario, it took a long time before he even revealed it to his family. Probably came into the United States without revealing it to the embassy, which acts against them as well, a legitimation. So that becomes a more and more problem. Now, it's only been 15 years. Probably the child is less than 18. But you can also show a bona fide father-child relationship. That's kind of the second alternative to legitimation. So if you can show a bona fide relationship, which basically means, are you supporting the child financially? Do you have an emotional involvement with the child? Have you seen the child? Have you gone visited? Have you, lived with the child at some point during their life? all of these things can be brought together to show that you have a bona fide relationship, and using that, then you can also, it's not legitimation, but you can also petition that child if you show a bona fide child relationship.
Okay, very quickly. What if you have a family here, the guy has a family here, goes back home to the Philippines often, has an illicit affair, starts a second family there. Now he wants not just one child, but maybe 2, 3 children out of that second marriage or second relationship to come here with him.
These are the same issues. It's a child born out of wedlock. You either have to legitimate the child in the Philippines, which we know is not possible, but you can do that here in California if they're going back and forth, if they support the child, if they show that they continue to have a relationship. Very difficult when you're leading 2 lives.
Right, exactly. And then another question is, does it matter if the father here is an LPR or a U.S. citizen?
No, it doesn't, and it actually works for both. It's more difficult with citizens when you're trying to transmit citizenship, because legitimation is the only way. You can't show the bona fide father-child relationship. You have to legitimate that child. And in some instances, you want to show that the child was not legitimated if you're trying to transmit through the mother. There was a recent case in which the court said the child was legitimated under the law of, I believe, El Salvador, and so therefore the mother could not transmit because it has to be an illegitimate child in that situation.
Right, or perhaps maybe you can talk about that next time here on the show. But if you have other questions related to this, they will certainly help you. Aquino and Low Law Firm, that's what I'm talking about. That's the number to call on the screen if you want to make an appointment now. And also you may consult via email, via website, and all that. Thank you so much. We'll see you next time. Happy New Year again.
Thank you. Happy New Year.
Redistricting of historic Filipino town. This is very important to us because this is our community. We shall talk about that when we return on the show. Don't go away.